Hello.
Hello, is that Mr. Koyama?
Yes, Koyama speaking.
Oh, that's good. Hello, it's Karen from Wellington High Court. I'd like to put you on hold for the judge for your conference.
Thank you.
Thank you.
Good morning, Mr. Koyama. Are you there?
Yes, I'm here.
It's Justice Dobson speaking. I have convened this conference to review the readiness of your appeal for hearing next week. Do you understand that?
Yes, I understand.
Good. Mr. Collins, are you there for this society?
Good morning, Your Honour.
I am a little concerned, Mr. Koyama, about the scope of the argument that you foreshadowed in your submissions. Justice Wilde, when he was dealing with the matter, made the point that the appeal would necessarily be confined to the merits of what was decided, but it does seem to me that your submissions place a lot of weight on criticisms of the process that was adopted by the tribunal, which we would expect to have been pursued by way of an application for judicial review rather than an appeal. Do you understand the distinction between the two?
Yeah, I understand it. Except my understanding is the second decision was on the July of the 2010. I understand still there was evidence of bias. Also, there were no hearing was conducted. It does seem to me this matter is an error in terms of how the procedure was being conducted by the tribunal. Therefore,
yes, if you wanted to advance those sort of criticisms, they are criticisms of process, as you have just said, not about the substantive correctness of the decision.
Well, my understanding is the decision was made in the 2010 July, and my submission is the decision was made by chairperson, which was biased.
I understand your allegation. That's being cynical about it. The substance of the decision might still be correct, even if it was made by a tribunal adversely affected by bias. And the way of determining the impact of bias and whether it was there is to pursue a judicial review, not an appeal. That was the caution that Justice Wilde was intending to flag in his minute quite some time ago.
I'm not a lawyer, and my understanding is under the Human Rights Review Act, the courts need to deal with the substantial issue.
Well, the substantive issue is whether the orders made by the Human Rights Review Tribunal in July 2010 are correct.
It was incorrect. There are many incorrectness that I mentioned in my submission. Number one, facts was incorrect. Human Rights Tribunal decision said I didn't submit the argument, and in fact I did it, and that was incorrect. Also, the Human Tribunal advice for the respondent issued the certificate character or something like that, but there was no need for that. There was many factual incorrectness in the decision, so the factually incorrect. Also, there were some arguments that Human Rights Review Tribunal put in decision was not submitted by the respondent, so that was incorrect as well too. There are so many incorrect factually in the decision. that is factually incorrect, and there are many things that are incorrect. So those were errors by in the decisions.
Well, assuming we're going ahead with this as an appeal next week, you've also raised a concern that you can't adequately prepare because you don't know what Mr. Collins is going to argue. Is that still a concern for you?
Yes.
Mr. Collins, what do you say?
First of all, I say I apologise. But secondly, that I will get my written submissions in tomorrow, and it will be no surprise to Mr. Koyama that it will be, well, in terms of acquainting the court with the issues on the appeal of the decision of the 19th of July 2010, it will be to traverse the issues and then essentially to say that it was rightly decided. So Mr. Koyama may acquaint himself with the arguments that I will be running by rereading the submissions I filed for that hearing back in, and my submissions were dated then the 30th of April 2010. So, Mr. Koyama, I apologise to you for no discourtesy is intended. I had overlooked, and I admit that I had overlooked that there was a pre-trial direction made by Justice Young. I've been very busy. I don't expect that to be a concern to anyone else, and don't offer as an excuse, but that I will ensure that you're given written submissions, and I will assist and atone for my sins by providing a bundle of documents for the court for the hearing on the 11th.
What do you say about the scope of arguments foreshadowed in Mr. Koyama's submissions?
Your Honour, I respectfully submit that they are misconceived and misguided so far as they relate to anything other than the decision appealed, which was concerned with my argument that the Human Rights Review Tribunal lacked jurisdiction to enter into an analysis of the complaint because there was no live complaint at the time of the transition from the Canterbury District Law Society to the New Zealand Law Society with the advent and commencement of the Lawyers and Conveyancers Act. And it's that when I say that I'm referring back to my earlier submissions, that those submissions are dealt with in the scope of the appeal can only be concerned, in my respectful submission, with the issues traversed in the judgment or the decision of the HRRT on the 19th of July 2010, which was solely concerned with the existence or not of a complaint which was capable of being investigated and determined by the Human Rights Commission and ultimately the Review Tribunal. The issue of bias was the subject of a separate decision, which was a determinative decision on the 18th of February 2010 and was not appealed or otherwise submitted for review or any other such process. That is my view of the status of the events that will occur in court on the 11th of July.
Mr. Koyama, what Mr. Collins is saying is that if you want to start getting ready, you can anticipate that his submissions he'll file for the hearing before me will be a rehash of the submissions he made on the date of the 30th of April before the Human Rights Review Tribunal. Do you understand that? Yeah,
then probably I wouldn't be ready next week. That's too soon for me to be ready for the new issues that have been raised by the...
You'll understand from the content of the various minutes that have been issued, the court is going to have this appeal heard. It has been hanging around far too long. In terms of the substance of your grievance, have you pursued a fresh complaint?
No.
Why not?
Well, my understanding is I had the right to appeal, so I appeal. And I don't know why should I file the new complaint when this case is still going on. I just don't know.
Because the view that the tribunal seems to have taken, if I understand their decision correctly, is that your indication, and I think it was September 2009, that you were dropping that complaint, meant that there wasn't something live when the Canterbury District Law Society morphed into the New Zealand Law Society. But that doesn't prevent you pursuing a fresh complaint. As I understand your concern, it is that the Law Society has dealt on a wrong basis with issues of character that you need them to help you with before you can get admitted as a barrister and solicitor in New Zealand. Isn't that what you really want?
I already received the certificate of character from the Otago District Law Society.
So, if I may, Your Honour, it is correct that the heart of the grievance is that the former Canterbury District Law Society refused to issue a certificate of character. That set in motion a chain of events with complaints to the Privacy Commissioner and the Human Rights Commission. But in the event, the Otago District Law Society received an application for the same thing and issued a certificate of character, and in due course Mr. Koyama was admitted. So he is on the roll as a barrister and solicitor of the High Court of New Zealand. He is not a practitioner. He's not a lawyer by the definition of that term in the Lawyers and Conveyancers Act.
I see. Because
he does not possess a practicing certificate. But so the real grievance is, with respect, concerned with ancient matters long surpassed by events. But nevertheless, Mr. Koyama may be entitled to complain to whomsoever he thinks, but there's no prejudice now to him in these past events, I suppose, is one point.
Okay. Mr. Koyama, the appeal will go ahead next week.
Yes.
If when you get Mr. Collins' submissions tomorrow, there are matters in them which have taken you by surprise because they have not been canvassed before, then that's something you can raise with me at the outset of the appeal next week.
Yes.
Okay? Because if you are prejudiced and you can establish that you haven't had enough time to deal with a new point, then I would consider giving you further time after the hearing to address those new points.
Yes.
But if Mr. Collins' assurance that he's given us on the phone this morning is borne out, i.e. that that the matters he's going to raise in response to your appeal have all been traversed before, then the court will expect you to be ready to argue the whole scale of it next week. And do you accept what Mr. Collins has told me, that you have since been issued a certificate of character and have been admitted to the bar as a barrister and solicitor in New Zealand?
Yes, I have been. Yes.
Right.
That's correct.
Okay. Well, you are by that act an officer of the court, and I am bound to treat you as I do all officers of the court. Do you understand the significance of that?
Well, my understanding is if you're licensed practice law in New Zealand, there are rules to abide with. But I'm not licensed to practice law in New Zealand.
No, that's a distinction. Yes, you're not licensed. You can't charge others. But in terms of your dealings with me as a judge of the court, I will be treating you as an officer of the court, because that's the consequence of your having been admitted as a barrister and solicitor.
Well, then you have to specify what the rules that I have to abide with, because the rules that I have seen is the one that for the practicing lawyer. I never seen any rules that apply to the barrister solicitor.
Well, in terms of presenting a case in court, what it does mean is that I am entitled to expect you to know the rules and to comply with them.
Yeah, yes, I try to do everything possible with the rules, yes.
Good. Okay, well, given the fact that you are admitted as a barrister and solicitor, I don't see any realistic scope for the argument that somebody else should be appointed by the courts to argue your case. I understand that at an earlier stage you sought from the Human Rights Commission for them to arrange representation for you, and they declined. Is that correct?
Director of Human Rights Proceedings declined, yes.
Right, okay. All right. Well, we're going to get the appeal on next week. As I say, it's unfortunate you haven't had more time to consider Mr. Collins' submissions, but given his assurance that there'll be nothing new in them, I'm not persuaded that you can establish prejudice in terms of your adequately preparing. You'll have the best part of a week. If new matters that take you by surprise are raised, then you should raise that with me at the outset of the hearing. You understand that?
Yes.
Okay. Are there any other matters you wish to raise about how the hearing should run next week?
What I like to see is the New Zealand Law Society to submit affidavit on the two matters. One is the exactly when Mr. Royden Hindle, the chairperson of Human Rights Tribunal, was hired as a faculty member of the New Zealand Law Society Litigation Skill Training Program. And I want to know how much exact amount being paid for being the faculty member by the...
Well, unless he was treated very specially, I can tell you I used to do that when I was a member of the bar, and you don't get paid anything.
Oh, you don't get anything.
Mr. Collins, I assume that's still the position?
I'm sorry, was Mr. Koyama saying that he wanted to know how much Mr. Hindle was paid to be the chair of the Human Rights Review Tribunal?
No, I understood him to say how much he was paid for being a member of the faculty of the Litigation Skills Program.
Sorry, okay. The answer to that is it's a purely voluntary activity on behalf of the good of the profession.
I think the complete answer, Mr. Koyama, is that if the faculty is drawn from practitioners all over New Zealand and their expenses for flying, I mean, the Law Society, if a course is held in Wellington or in Christchurch, then the Law Society will pay for the airfares, and they put them up in a pretty Spartan accommodation whilst they're there, but they are not paid.
Yes, I understand that.
Are there other matters you want to clarify?
No, that's the matter that I thought was necessary.
Yeah, no. Well, it's like a lot of things. The Law Society expects its members to give back, and it's not in the practice of paying anybody for doing things like that. All right, Mr. Collins, are there any other matters about the way the course of the appeal ought to run from your perspective?
Two things, Your Honour. Thank you. One, I invite Mr. Koyama to call me and talk about the submissions and the position I'll be taking. I'm very happy to talk to him directly and to cut through any misunderstanding if that can be achieved today or tomorrow or whenever. An open invitation. Second, I will prepare a bundle that will assist the court. Now, in saying that, there is some background in which Mr. Koyama was cautioned and told not to file vast quantities of documents with the HRRT earlier on. But if it would be helpful to the court to have a copy of the record of the decisions of the HRRT, which would include the decision on bias and any submissions about that, just so that there's some background if this raises its head on the 11th, and of course a copy of the decision being appealed from, and the parties' submissions in relation to that hearing, which was on the papers.
I have certainly got the decision being appealed from, and I have one form of submissions from each party before the HRRT, but I would be grateful if you're including in that bundle anything that you think we might stray into.
Well, it would be the bias decision, sir, which was an intensely felt issue on Mr. Koyama's part earlier on.
Yeah.
So if I include that material and I circulate a bundle of indexed and tabulated documents to the court and to Mr. Koyama by the end of, shall I say, by the end of the day on Thursday. Yeah. Would that be acceptable and helpful?
Yes, it will be. Thank you.
All right. So that was all from me, Your Honour.
Okay. All right, Mr. Koyama. Well, we will get this appeal on, and the hearing will run as I have foreshadowed it, and I look forward to seeing you on the 11th. Okay?
Thank you.
All right. Thank you both.
Thank you, sir.
Goodbye.